Amendment 15. Now, the Streets Lazy app for the Interaction Constitution has changed its format, so the layout will be different. Let's first read the text. Right to vote not denied by race. Passed by Congress February 26, 1869, ratified February 3rd, 1870. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have the power to enforce this article by appropriate legislation. Common interpretation by Richard H. Fides and by Brandley A. Smith. Most Americans probably believe the right to vote is one of their most fundamental constitutional rights. It will come as a surprise, therefore, to learn that neither the original Constitution nor the Bill of Rights or any other provision of the Constitution expressly guarantees the right to vote. Only in the 1960s, when the Supreme Court began to conclude that the 14th Amendment implicitly protects the right to vote, did the American constitutional doctrine begin to treat the right to vote as a fundamental constitutional right. Once the court recognized the right to vote, decisions of the Supreme Court helped revolutionize the way voting was treated under American constitutional law. Most of the law concerning the right to vote developed under the 14th Amendment, though important court decisions also have relied at times on the 15th Amendment. The reason the original Constitution, the Bill of Rights, do not expressly protect the right to vote is that doing so would have been too controversial and divisive at the time. Different states had different rules for who could vote. Many states have property holding requirements and differed on the amount. Some states permitted women and free black men to vote, others did not. To create a uniform standard across the country would have required resolving these major differences. The only place where voting is directly recognized in the original Constitution is for choosing members of the House of Representatives. Article 1, Section 2 provides that the people eligible to vote for members of the U.S. House will be determined by whom the states let votes for their own House of Representatives. Since the Civil War, many constitutional amendments address voting issues, but these amendments are written to prohibit certain bases for denying the vote to some people once the vote is extended to others. The 15th Amendment prohibits racial discrimination in the vote. In the 19th Amendment prohibits discrimination based on sex. The 24th Amendment prohibits the use of poll taxes in national elections, and the 26th Amendment prohibited denying the vote to those over 18 years of age. But in terms of constitutional decisions of the Supreme Court, the two most important provisions with respect to the vote have been the 14th and, to a lesser extent, the 15th Amendments. Although the 14th Amendment was not designed to protect the right to vote and does not expressly mention it, two lines of Supreme Court decisions have provided important protections since the 1960s. In the first line of cases, the Supreme Court created the one vote, one person doctrine, which required that there must be fairly equal numbers of people in election districts when electing representatives to a political body. For example, all the congressional districts in the state must have the same number of people. Before the decision in Baker versus Carr, 1962, Reynolds versus Sims, 1964, and similar cases, some districts in the state might have 900,000 people, others are only 10,000 100,000 people, but the voters in each district would elect one representative to Congress. The court concluded that the 14th Amendment reflected the principles of political equality that requires each district have, to the extent possible, an equal number of residents, which is what one vote, one person means. The second area for important decisions involved the right to get to the ballot box and cast a vote. Again, under the 14th Amendment, the Supreme Court first began to recognize this right in the 1960s. In Harper versus Virginia Board Elections, 1966, Dunn versus Blomstein, 1972, and many other cases, the court decided that restrictions on who could vote would be subject to strict scrutiny as the most demanding judicial standard. Once this standard was announced, the court quickly held unconstitutional virtually all restrictions on voting other than 1. Citizenship, 2. Residence in the jurisdiction, and 3. Age under 18. To invalidate other regulations on the voting process, the court in later cases, such as Burdick versus Takushi, 1992, and created a two-part test that first requires court to decide if a burden on the right to vote is severe or not. If it is, the regulation can survive only under strict scrutiny, which most regulations fail. But if the burden is not severe, the regulation is much more likely to be upheld. Most current constitutional controversies about regulations of the voting process take place under this Burdick framework and requires court to decide, first, whether the regulation imposes a severe burden on the right to vote. And due to the Constitution in 1870, the 15th Amendment was the final of the 3 constitutional amendments enacted during Reconstruction in the aftermath of the Civil War. While the 13th Amendment prohibited slavery and the 14th Amendment barred states from denying equal protection of the laws, and the 15th Amendment established that the right to vote could not be denied on the basis of race. Though its express terms prohibited all racial discrimination in voting qualifications, the amendment was aimed at ensuring the enfranchisement for African Americans. Section 2 of this short but momentous amendment also gave Congress the power to enact legislation to enforce a right against race-based denials of the vote. The constitutional meaning of the Civil War was reflected in these 3 amendments. When the 15th Amendment was passed, it represented the principle that African American citizens, most of them former slaves, were now entitled to political equality. Yet the most significant fact about the 15th Amendment in American history is that it was essentially ignored and circumvented for nearly a century. This history illustrates that constitutional rights can be little more than words on paper unless institutions exist with the power to make sure that the rights actually enforced. For the first 20 or 30 years after the amendment was adopted, black adult women were generally not permitted to vote at this time, were indeed permitted to vote, and did so in large numbers. Nearly 2,000 African Americans were elected to public offices during this period. But starting in 1890, Southern states adopted a real law that made it extremely difficult for African Americans and many poor whites to vote. This was the start of what is known as the era for disenfranchisement. It lasted all the way up until 1965. These laws require people to demonstrate literacy, or prove good character, or pay certain voting taxes, overcome other hurdles before they were permitted to vote. As a result of these laws, African American voting in the South was kept at extremely low levels from 1890 to 1865, despite the 15th Amendment. Early on in this process of disenfranchisement, the Supreme Court was asked to hold those laws unconstitutional, but in a 1903 case called Gales versus Harris. 1903, the Supreme Court refused to do so. The court stated that it did not have the power to force Southern states to comply with the 15th Amendment. Later that year, in James versus Baldwin, 1903, the court held that the amendment did not authorize Congress to punish private individuals who interfered to prevent African Americans from voting. The Supreme Court did eventually invoke the amendment to hold unconstitutional a few of the specific laws that sought to block African Americans from effective political participation. In 1944, for example, the court held unconstitutional rules that in some Southern states prohibited black citizens from voting in political primary elections. Smith versus Allwright, 1944, in a well-known case. Gomilin versus Lightfoot, 1960, the Supreme Court held that the city of Tuskegee, Alabama, and violated the 15th Amendment when it redrew the city's boundaries from a square to a unearthly 28-sided figure that put the residence of nearly all black people outside the city's boundaries. Yet for 1965, it was still the case that in Mississippi, for example, nearly 6.3% of African Americans was able to register to vote. The situation only began to change dramatically in 1965 when Congress used the power to enforce the 15th and the 14th Amendment by enacting the Voting Rights Act for 1965, the VRA. The VRA provided a variety of means for the federal government and the federal courts to ensure that the right to vote was not denied on the basis of race. In modern constitutional law, the 15th Amendment plays a minor role. The reason is that other broader sources of law have emerged to protect the right to vote. In the 1960s, the Supreme Court concluded that the 14th Amendment protects the right to vote as a general matter, while the 15th Amendment is more limited to protecting against only race-based denials of the right to vote. In addition, federal statutes such as the VRA and others now exist to protect the right to vote as well. When cases involving issues of race, the vote are brought today, they will typically be brought simultaneously under the 15th and 14th Amendments, as well as the VRA. If a law explicitly imposes different rules by race for access to the ballot, there's a little doubt the court today would hold such a law to violate the 15th Amendment. One case like this in recent decades came from Hawaii, where the law permitted only native Hawaiians, not all Hawaiians, to vote for certain officials. The Supreme Court concluded that a law limiting who could vote based on their ancestry was equivalent to the law that limited the vote based on race, and that Hawaii's law therefore violated the 15th Amendment. Rice versus Cayetano, 2000. But if a voting law does not impose different rules by race, it is challenged as nonetheless racially discriminatory. The court has concluded that the challenger must show that the law is based on the racial discriminatory purpose before the 15th Amendment is violated. Mobile versus Baldwin, 1980. Although the 15th Amendment does not play a major independent role in cases today, its most important role might be the power it gives Congress to enact national legislation that protects against race-based denials or abridgments of the right to vote. Matter of debate. The first perspective, the feature of voting rights, finding the right balance, by Brandley A. Smith. While voting regulations based explicitly on race are clearly unconstitutional under the 15th Amendment, the situation grows more complicated when the practice is not explicitly race-based, but may nonetheless depress minority voting. The requirement that voters register in advance, for example, may dissuade some minority voters from registering, yet is almost universally accepted. The mere fact that an otherwise valid election regulation or practice inconveniences some voters does not create a constitutional violation. Current controversies of voting rights often revolve around this problem. Two examples: voter ID laws and the restoration of voting rights to felons. In the last 20 years, numerous states have enacted laws requiring voters to present proof of identity and or citizenship at the polls. States argue that these laws help to prevent fraud and assure orderly elections. Critics argue that the racial minorities, among other groups, are less likely to have such documentation than whites, and at the time the expense of obtaining such documentation constituted a barrier to minority voting in violation of the 15th Amendment and the Voting Rights Act, VRA. If such laws can be shown to be racially motivated, they violate the 15th Amendment. But racial motivation is hard to prove, either because the true motives are easily hidden or because race simply is not the motivation for the law. Absent proof of motivation, do such laws violate the 15th Amendment or the VRA? In Crawford versus the Marin County Election Board, 2008, the Supreme Court upheld Indiana's voter ID law. The plaintiffs argued that evidence of fraud that could be combated by the law was almost non-existent. The plaintiffs, however, failed to produce evidence showing that the law actually had a significant impact on persons who wished to vote. In short, neither side could answer the question, does the law prevent more illegal votes or deter more otherwise eligible voters from voting? In light of the lack of evidence on both sides, the court's ruling upholding the law appears correct. The court decision left open the possibility that the further plaintiffs who could prove discriminatory effect might again challenge the law, and that too appears correct. Restrictions on the voting rights for convicted felons pose similar issues. As for 2015, 48 states have placed some limit on voting by convicted felons. In some states, voting rights are restored once the felon is finished the term for incarceration. In others, restrictions remain during parole and or probation. In 11 states, however, voting rights may be permanently revoked. In recent years, for reasons beyond this discussion, high felony conviction rates have led African American males to become over 1/3 of all persons prohibited from voting due to felony convictions. Do such laws, therefore, improperly burden minority voting rights? Or are restrictions on voting by convicted felons a legitimate public policy and a form of punishment? In Richardson versus Ramirez, 1974, the Supreme Court held that a disenfranchisement of felons was not a per se violation of the 14th Amendment's Equal Protection Clause. But in Hunter versus Underwood, 1985, the court held that such a law would violate the 14th Amendment if enacted with a racially discriminatory purpose. Neither case was decided on the 15th Amendment. Constitutionality aside, the wisdom of permanent disenfranchisement may be questioned. Permanent disenfranchisement is a barrier to felons' ability to successfully reintegrate into society. Moreover, it has become a sore point in much of the African American community that may not be worth whatever deterrent or punishment effect it has to a jail term. A more enduring conflict has been the use of the VRA to require states to establish majority-minority voting district, in which minority voters comprise a clear majority of total voters. In Allen v. State Board of Election, 1969, the Supreme Court held that the VRA applies not only to laws that directly disfranchises minorities, but to rules that dilute minority voting power by making it harder for the minority group to elect its preferred candidates. For example, if a county is a population 25% African American, and it elects 3 county commissioners from the county as a whole, and if voting is racially polarized, it's unlikely that the elected commissioner will be the choice of the African American community. But if the county is divided into 3 districts, each electing 1 commissioner, it is possible to create 1 district within the majority African American population that can elect that group's preferred candidate. The forced creation of a majority-minority districts under the VRA undoubtedly helped assure African American representation in numerous legislative bodies in the 1970s and 1980s. In recent decades, however, the practice has become increasingly controversial. Because African Americans vote overwhelmingly Democratic, the creation of majority-minority districts effectively packed large number of Democratic African American voters into a relatively small number of districts, leaving surrounding districts both more white and more Republican. So while more minorities are elected, they are more likely to serve in legislative bodies controlled by the opposing party. Further, some argue that legislators from other districts which have been bleached of their minority voters who were packed into the majority-minority districts have little incentive to concern themselves with the particular problems of minority communities. Thus, whether majority-minority districting arguments or disgraces minority political power is increasingly in dispute. Others argue that the very process considering race when drawing district boundaries violates the purpose of the 14th and 15th Amendment. Justice Clarence Thomas described the creation of a majority African American district and segregating the races into political homelands that amounts, in truth, to nothing short of a political apartheid. Holder v. Hall, 1994, concurring in judgment. In Georgia v. Ashcroft, 2003, the Supreme Court relaxed the majority-minority districting requirement, holding that considerations of broader minority influence were relevant in deciding not to create majority-minority districts. However, this interpretation was overturned by Congress when it renewed the Voting Rights Act in 2006. Support for majority-minority districting under the VRA depends on many factors, including the degree to which one believes that the United States remains a racially polarized society, that the interests of whites and minorities are opposed, and that the whites and minorities can form electoral coalitions. It is also influenced by perceptions of how legislative bodies operate and whether a minority group's power is maximized by its ability to elect a smaller number of its members or to influence but not control the election of a large number of legislators. Justice Thomas' critique is a powerful claim that whatever short-term advantages minority groups may gain from majority-minority district is more than offset by the long-term damage to race, relations, and democratic norms. The other perspective, the 15th Amendment, the right to vote today, by Richard H. Fields. Current controversies over the right to vote can be divided into 2 types of claims. The first involves the ability to get the ballot box and cast a vote. These are called the first-generation voting rights claims because they involve the basic right of being able to vote at all. The second involves the way election districts are designed. even once all eligible voters are properly able to vote. The way districts are designed can affect the distribution of political power between various groups in society, particularly the relationship between political majorities and minorities. These kinds of claims about the fair design of election districts are called second-generation voting rights claims. First-generation rights to vote ensues. The most dramatic issues in this era were fundamentally resolved during the Supreme Court's right to vote revolution in the constitutional law during the 1960s. That body of law established that most restrictions on who is qualified to vote other than those concerning citizenship, residency, and age under 18 will be subject to strict scrutiny, a very demanding standard which requires the government to show restrictions are necessary to further a compelling governmental interest and are likely to be unconstitutional. For several decades after this revolution, there was not a lot of controversy or constitutional cases involving the basic right of access to the ballot box for all adult resident citizens. In the late 2000s, however, constitutional and political controversies arose over how the process of voting was structured and regulated. This controversy did not concern primarily who are eligible to vote, but what the ground rules of election would be. One type of controversy centered on what a voter would have to do to prove that they were in fact eligible to vote. A significant number of states passed new laws that require voters to provide a more extensive proof and documentation of their identity, such as various forms of photo identification before they would be allowed to vote. A smaller number of states passed new laws requiring voters to provide greater proof of their United States citizenship than had been required in the past. A second type of controversy emerges over how easy and convenient voting should be. To make political participation easier and more accessible, a number of states in the early part of the 2000s passed laws that permitted voters to register to vote at the same time that they cast a vote, as opposed to many weeks in advance of the election. Even more states passed early voting laws which enable people to vote, not just on one day, election day, but up to several weeks in advance of the election, including on weekends. A number of states that had made voting easier through these kind of laws have decided in more recent years to cut back on the scope of those options, such as by reducing the number of days for early voting. These cutbacks on access to voting have also triggered constitutional controversies. In virtually every state that has enacted new requirements for proof for eligibility to vote or cut back on access to voting, the laws were passed on strict party line votes. Republican vote in favor of these laws, Democrat against. That has given an intense partisan political cast to these constitutional controversies as well. Critics of these laws argue, 1. There is no serious need for new laws concerning proof of citizenship or identity because there is no real evidence that under the previous long-standing laws, voters who were not eligible were actually voting. 2. These laws are likely to suppress voting and make it more difficult for eligible voters to vote. And 3. These laws are passed for partisan purposes because those more likely to vote Democrat are less likely to have the relevant documents even when they are eligible to vote. Proponents of these laws argue they help ensure the integrity of the political process. Similarly, critics argue that there is no good reason to cut back on methods that make it easier to vote and that the only reason for doing so is to make it harder for certain groups of voters to vote. The framework of the courts used to decide whether any of these laws are unconstitutional is set by modern cases like Crawford versus Marin County Election Board 2008 and Burdick versus Takushi 1992. Do these laws impose a severe burden on the white vote, on a reasonable, non-discriminatory one, and does the state have a good enough reason for enacting these laws? In Crawford, the court concluded that laws requiring proof of identity to vote on the per se unconstitutional but left open the possibility that the particular voter identification laws might be unconstitutional if they imposed a severe burden on the right to vote without sufficient justification. The Supreme Court is just beginning to sort these issues out. At the time of this writing, there are several major cases pending before the court on these novel issues. The Constitution already required that the voters and the ballots they cast be treated equally during the voting process. That principle flows from Bush v. Gore 2000, which required that in a presidential election, all ballots being manually recounted during a disputed election had to be counted under a method that would ensure all ballots would be treated uniformly. The lower courts have applied this principle to hold, for example, that laws can permit certain groups of voters to vote early, but not others without adequate justification. Second-generation right to vote ensues. The biggest controversy in this area centers on the property rule that the considerations of race and ethnicity ought to play in the design of an election district. In the Voting Rights Act, when blacks and whites vote in dramatic opposition to each other, voting is racially polarized. Election districts must be designed to make black voters a majority in a certain number of districts, to ensure a fair opportunity for all groups to elect candidates they prefer. But at the same time, the court has concluded that if states use race too much in the design of districts, the Equal Protection Clause is violated. If that sounds complicated, it is. Too little attention to race can violate the Voting Rights Act, but too much attention to race can violate the Constitution. There is also policy disagreement about which way of designing districts is in the best interest of minority voters. Are they better off being a majority in a few districts so that they can control who get elected there? Are they better off being a significant presence in many more districts even if they do not constitute the majority in any of them? This issue is also becoming increasingly complex as America becomes more diverse, particularly with the dramatic rise in the Hispanic and the Asian population in recent years. The question of how to design a system of fair political representation and what role the Constitution plays in that process have become increasingly complicated. Let's end this amendment.